In a moment, I'm going to have him kick things off. And then when he wraps up with his opening thoughts, I'm going to invite you to ask him questions in the order that you RSVP'd. But just a heads up for some housekeeping, the Senate just announced a vote, and then Senator King also needs to run to the Intelligence Committee. So I'm going to squeeze as much as I possibly can until I get a hell stare from the schedulers here in the office in the heart. First, if you would like to ask a question, send Dana Young and Top a chat during the Zoom. We will call on you so that you can unmute yourself. You do have to unmute yourself after we grant you permission. We're doing that to keep the audio quality crystal clear for the broadcasters, audio and video here, who are participating in this virtual press conference. One additional cybersecurity thing, the Senate Zoom suite does not allow participants to record directly through Zoom. That's controlled by the Senate cyber team, fully out of our control. If you want to record on your side, we recommend you do so with third-party software. That being said, we will be sending around a recording and a rough transcript of the press conference shortly after it's over, probably within an hour or so. That being said, I'm going to get this thing underway. And Senator King, tell us what you introduced today with Senator Murkowski and why you think it's important and the right approach.
Well, the bill that Lisa Murkowski and I introduced is very simple and straightforward. It does not prescribe a code of ethics for the Supreme Court. It basically charges them with doing that themselves. This is a pro-Supreme Court bill. It is designed to help the court reestablish its important reputation and the respect that it has throughout the country. Recent revelations have necessarily put a spotlight on the necessity of legislation like this. Frankly, it's a shame that we have to do this. And I note that Chief Justice Roberts responded to Senator Durbin's invitation to appear before the Judiciary Committee. He declined to appear, and then there was a sort of vaguely worded, "We will follow the substance of the federal judicial canons of ethics." I don't understand why it's so hard for them to say, "We will follow the federal judicial canons of ethics." Let me be clear. Virtually every judge in the country, whether it's in a state or the federal system, has to follow the canons of ethics. In Maine, we have them, and for the entire federal judiciary, except the Supreme Court. And I don't really understand that exception. And so what we're really talking about today is simply bringing the Supreme Court into alignment with the judicial process in the rest of the country. And the reason is that the court, uniquely in our branches of government, is not elected. Their authority really rests upon their credibility and their integrity and the demonstration of integrity. And so what Lisa Murkowski and I are trying to do is help them to reestablish that reputation. Unfortunately, the Supreme Court in the last year or so has fallen to its lowest level in terms of respect and confidence in the American public. And I think that's bad for the court. It's bad for the country. So we're trying to help the court to help themselves, if you will. And the fundamental one of the fundamental premises, and of course it would be foolish to deny that part of this discussion is based upon the recent revelations about Justice Thomas and Justice Gorsuch, but the fundamental precept that I remember learning in law school about judicial code of conduct is that a judge shall avoid impropriety and should avoid the appearance of impropriety. And that's a very high standard, but that's the standard that our judges across the country are held to. And I see no reason whatsoever why the United States Supreme Court, the most important court in the country, should be held to a lower standard, or indeed now it's essentially no standard. And so again, the bill is very simple. It's 3 pages long. It doesn't prescribe a code of conduct. It doesn't say what the rules should be. It just says within a year, the court shall establish its own code of conduct, which would be published and publicly available. And an individual whose job it is to see that the code of conduct is being followed and to process any complaints or questions that arise under it. It's very straightforward, very simple, and it's designed, again, to shore up the reputation of the court. And I understand Justice Roberts not wanting to appear before the Senate Judiciary Committee, but what I do think he should have said, instead of "we're going to adhere to the substance of," that's lawyer talk for we'll pick and choose what we decide to abide by. He said we'll apply the substance of the federal judicial canon of ethics, and I don't think it should be the substance of it. I think they should abide by it, just like every other judge in the federal system. So that's essentially what we're doing. I'm sure one of your questions will be, can you get this? Is there any chance of moving this in the Senate? We're starting with a bipartisan bill. I know Senator McConnell made some statements this morning on the floor that were basically saying we've got no problem. It was the senatorial equivalent of "there's nothing to see here." But I think everyone in America knows there is something to see here. And again, I want to emphasize, we're trying to essentially save the Supreme Court from themselves, because this is clearly a gap in the administration of justice in this country that we're trying to help them to cure. So with that, I'll stop and be glad to answer questions.
All right. Thank you very much, Senator. And if you do have a question, a reminder to send Dana Young and Todd a chat during this Zoom, and we will call you in that order to unmute yourself. First up, Abby Van Sickle, your question for the Senator.
Yes, thanks. I was curious of what the enforcement mechanism is for the court in your bill. What forces them to have to abide by this?
Well, I think the enforcement mechanism is, once there are standards, then all of this transparency is the enforcement mechanism, if you will. We're not talking about sanctions or any of those, any kind of penalties. But what we're saying is establish the standards, and then there will be transparency in terms of any charges of violations of those standards and what disposition the court has made. The problem we have now is that there's no standard. So a justice can say, "Well, I didn't violate anything here." The reason they can say that is that there's nothing to violate at this time. So the enforcement, I think, will really be the transparency in reporting of any misallocation of resources or failure to meet the standards that the court itself we're asking to prepare.
Thank you, Abby, and thank you, Senator. And again, if you have questions to ask Senator King, please send Dana a chat during the Zoom, and we'll call on you in the order that comes through. Next up, Chris Costa from Maine.
Let's see. Hi there, Matt. Hi, Senator. To kind of piggyback off of Abby's question, I'm curious what the penalty would be for a justice who does not follow this code of conduct. Because as you know, they're sworn to serve for life. And then I guess my second part of that question to you is, since we're allowing the justices, or would be allowing the justices, to make their own code, in your mind, what makes a good code? What would be appropriate and acceptable to you, and what would not be acceptable? Thank you.
Well, in answer to your second question, it would be really easy. If I were doing the drafting, I would just have a one-sentence addition to the current federal judicial code of ethics saying this applies to the U.S. Supreme Court as well as every other judge in the federal system. This is a carefully worked out set of ethical guidelines or standards that have been in place for many years, have been worked through by judges across the country and by the various officials of the court system. So defining the standards isn't tough. They're already there. Or look to the standards of virtually any state for judges. This isn't a challenging drafting. We're giving them a year. It probably could be done in a week. And I think that's what's really important here. What are the penalties? I don't think we're really talking about penalties here. And if you look at the standards of judicial ethics, either on the state level, I read Maine's again this morning, or the federal level, I read those again this morning. They're not talking about penalties. They're just talking about what should the conduct be. And obviously, federal judges are in for life. They're subject to impeachment like any other federal official, but only for significant, I think I don't think, I know the term is high crimes and misdemeanors. So it's not likely that a violation of such a standard would rise to that level, but it would at least, and remember, part of this is public. It would make any transgressions of the standards public. But the whole idea is to not have transgressions. But right now, as you say, there are no standards. I mean, as I said, there are no standards. And so there's no such thing as a clear-cut transgression. My belief is that if the standards are established along the lines of those in the federal rules or in various state rules, then that will act as a deterrent to activities that will bring discredit on the court. And again, remember, I'm not attacking the Supreme Court. I'm supporting the Supreme Court. We're trying to create something that will help to restore the confidence of the public in the Supreme Court, which is critically important to the functioning of our entire federal system.
All right. Thank you, Senator. And thank you very much, Chris, for the question. Tierney from CNN, you have a question.
Hi, thanks for having the press conference. It's notable that this is a bipartisan bill. I'm wondering if you have heard anything more from any Republicans besides Senator Murkowski about their interest in working in this space, and relatedly, if there's aspects of this bill compared to the other Supreme Court ethics reform bills that have floated around that you think will make it appealing to the Republican side of the aisle.
Well, the answer to your first question is that we just introduced the bill tomorrow, and Lisa and I haven't had a chance to do our missionary work. So I haven't yet been able to determine what level of support I can or we can generate on either side of the aisle. Our bill is somewhat simpler than the other bills that are out there. It's the only one that's bipartisan, and it's more straightforward in terms of, it's really, as I say, it's a 3-page bill. Establish the standards and set up a structure for maintaining the process of determining potential violations of those standards, and importantly, that the whole system should be public and in the open. So, in terms of bipartisan support, we haven't started that work. I'm hoping that we can. And again, I keep stressing this. We're doing this for the court. They should have done it for themselves. I have to say, I think it's sad. It's a sad day. I just emailed a friend of mine from law school and said it's a sad day that we're having to do this. The court should have done this years ago, and it's unfortunate that it's happening now. Does it have anything to do with recent revelations? Which, yes, because that sort of has elevated the importance of this question, and I think it's revealing that Justice Thomas had justified some of his receipt of various benefits as being okay. He said, I've consulted, people said it's not in violation of the rules. Well, there aren't any rules. So that's really what we're trying to get at.
All right, thank you, Senator. As a reminder to those of you who are tuned in, if you have a question, please send Dana Young and Top a chat during the Zoom. And we'll call on you in the order that you do so, and you can unmute yourself at that point. Next up, we have, pardon me, Stephanie from WGME.
Hello, can you hear me?
We've got you loud and clear.
Okay, great. Hi, Senator. It kind of goes off of your the penalty, but more so, some say a code of conduct would open up Congress's power to require recusal. Do you see that affecting some cases potentially?
No, I'm not. I don't think we're at that point. Again, to me, the importance is establishing the standards and establishing a public process as to whether the standards are being met. I suspect that if you had clearer standards, you wouldn't need to get to the penalty stage, because very few, if any, judges would violate the standards. I mean, as I say, this system is in place now for every judge in America, every federal judge, and I assume every state has a code of conduct for judges, just as Maine does. And you rarely, if ever, hear of any kind of activity of enforcement or penalties under those standards, because judges are pretty good at following the law if they know what the law is. And right now, everybody knows what the law is except Supreme Court justices. There's no guidance. And I think it's clear that one of the areas that we need to define is what are the ethical constraints on Supreme Court justices for things like receipt of gifts, travel, honoraria, all of those kinds of things, and vague reassurances from the Chief Justice that we're going to consult the substance of the rules doesn't cut it for me.
All right, thank you, Senator. Again, if you have a question, please make sure to just raise your hand by sending Dana a chat in the Zoom, and we'll call on you as soon as we can. Next up, Doug Rooks. Doug, what's your question for Senator King?
Doug Rooks, there's a name out of my past.
Hi, Senator.
Hi, Doug.
Good to see you again.
Yes, sir.
I had a question more about process. Do I assume correctly that this is likely to go to the Judiciary Committee?
Yeah.
Your bill? Yes. Okay. As you know, the Judiciary Committee is kind of in a bind at the moment. The former chair, Senator Feinstein, has not been able to attend to her duties for some time. Senator Durbin, who is also the assistant leader, is chairing the committee in her absence. This seems to be a tough time to try to move legislation through the committee. Is how long can this important committee, which presumably is going to be pretty key to this dilemma, how long can they go without a full membership?
You've really asked two different questions. I really can't comment on the situation on the committee and when Senator Feinstein will be back. That's a separate issue. It's true that's a significant one because it's although we did have a little bit of breakthrough. I think it was last week that the deadlocked committee did release a number of judicial nominees, so they aren't all being held up by the tie vote on the committee. In terms of our proposal, this is a bipartisan proposal. Lisa Murkowski and I are putting it forth. We're going to look for support from across both caucuses. Look, this problem is not this issue is not going to be dealt with except on a bipartisan basis. So if we can't get Republican support on the committee, it's going to be very difficult to move the bill out of committee and onto the floor. I'm hoping that my Republican colleagues, many of whom I work with and know very well on the committee and in the caucus generally, will see this not as Senator McConnell characterized it this morning as some kind of attack on Republican appointed judges. I honestly believe that I would be having the same discussion regardless of any activity of any judge, whoever appointed them. This is just something, as I say, it should have been done a long time ago. Recent events have made it clear why this is necessary, but it's not an attack on any justice. It's an effort to shore up the credibility of the Supreme Court in the public mind, and that's a real problem. And as I say, a poll I saw in the last few days is that the Supreme Court is in the lowest level of esteem in its history, and because it's not an elected body, it really is based upon its sort of moral authority. That something like this, I think, will help to restore confidence in the court.
Okay, thank you, Senator. Time is running low. We got to get the senator up to the Senate floor for a vote shortly. If you have a question, please flag Dana in the Zoom to let us know that you want to ask Senator King a question. In the meantime, we have Daniela from the Wall Street Journal. Daniela, are you there? What's your question?
Hi, yes, I am. My question is, do you think that Justice Thomas has done something that violates any statutes? And would any of the code of conduct proposals that might come forward, do you have any sort of baseline standards for what they would have to include?
Well, that's a good question, and I'm not going to set myself up as in this context as judge, jury, and executioner. I did review, as I mentioned, the judicial standards both in Maine and in the federal system, and there are some areas that I think that the Justice Thomas did skate pretty close to. In Maine, for example, the rule is you don't have to report or worry about what they call ordinary hospitality. I think that's the term, ordinary hospitality. Well, around the world, yacht trips is not ordinary hospitality, at least not where I come from in Maine. And I mean, look, the level of gifts and value that was bestowed on Justice Thomas and his wife is extraordinary. I mean, to say, there's nothing to see here, I just don't think is valid. But again, what we're proposing is not backward looking. We're not proposing any penalties on Justice Thomas. What we're saying is, look, let's put some rules of the road in so that it's more clear. And let's take Justice Thomas at his word that he thought he was doing something that wasn't a problem, and he didn't have any intent of doing anything outside of the boundaries of the rules. Well, it now appears that without rules that you have conduct that I think an ordinary person would say this is not good. And remember, the standard of judicial ethics isn't impropriety. It's the appearance of impropriety. And it's hard to argue that anybody in America thinks that what we've observed here doesn't come pretty close to violating that standard.
All right. Thank you, Senator. I think we have time for one more question. Anne, would you like to pose your question to the Senator? All right, Senator, what would happen after a year if SCOTUS did not adopt a code on its own as envisioned by the bill? Is there anything Congress could do to impose or enforce such a code?
Well, that's a good question. And I can't imagine if Congress passed this requirement that the court would not abide by it, because to not do so would be one more blow to the court's reputation and prestige. It would just be, another strike that would undermine confidence in the court. I can't believe that Chief Justice Roberts wants his legacy to be the lowest level of respect for the Supreme Court in American history. And I believe that with a nudge from the Congress and saying, look, we're not going to tell you what the standard should be, but you adopt those that you think will be appropriate, make them public, and then see that they're abided by with some kind of mechanism within the court. To me, that's not a radical attack on the court. It's an effort that Senator Murkowski and I believe is important to restore the respect and authority that the court holds in our society, which is extraordinary around the world. So again, I think it's long overdue. Should have been done many years ago. I'm surprised the court didn't do it itself. And vague assurances are not going to do it. I said a while ago, it doesn't cut it with me. The real question is, does it cut it with the American people? Because it's their relationship and respect and the abiding by the authority of the court that's really important here. So thank you all for your time, and we'll look forward to working with you and keeping you abreast of the progress of this bill.
All right. Thank you very much, Senator King. Head on upstairs and vote.
Yes, sir. Thank you.